Good afternoon, everyone. My name is Christine McWilliam, and I work with the Alzheimer Society of Alberta and Northwest Territories. I will be a bit of your host for this afternoon. I'd like to remind everybody that we are open and we are still working remotely from our homes, but all of our services are available. So if you do need them, please give us a call to connect, and a client service staff will be able to help you out with that. As well, at the end of this presentation, there will be a survey that will be sent along with the thank you email. If people could please fill that out, that would be greatly appreciated. If you do not receive anything, please check your junk. It's very possible it may end up there. As well, at the end, you will be redirected to one of our donation pages. And right now, people living with dementia need support more than ever. These are challenging times and the needs are great. Our services are free of charge, and we're asking that if you're able to help more families receive the support they need, to please donate. Thank you for your continued support. And now I will present our two speakers for the afternoon. The first is Alexis Dallaire. She spent most of her life in Edmonton and attended Grant MacEwan University to study psychology and sociology. For many years, while working and raising a family, helping people has always been a passion. This passion led Alexis to join Investors Group in 2014. Though family, Investors Group has always been a part of her life, and she brings so much experience to the table beyond her tenure as a consultant. She is dedicated to guide and protect our clients through wide-ranging investment and insurance strategies to ensure that their families are successful today and tomorrow. Our next speaker is Cam Lowe. He was born and raised in Alberta. Cam went to NAIT to study business and accounting. After 12 years with an international millwork company, he left the role of corporate purchasing manager to join Investors Group, with whom he had already been a client for 17 years. His experience in financial statements, budgeting, forecasting, and developing relationships transitioned well into his role with Investors Group as a certified financial planner and registered retirement consultant. Over the past 12 years, 3 of which were in management, he's focused on clients' well-being by providing comprehensive financial planning. Like many others who have come to know the Alzheimer Society, he also has a family member living with dementia and truly knows the importance of proper financial planning. So without further ado, I will ask Cam to turn on his mic, and as well as Alexis, and please take it away.
Well, thank you very much for the kind introductions. Like this year has been full of change, we do have a slight change today where I will be doing all of the talking today. And I'd like to thank everybody who's online for your time and support. With IG Wealth Management, we've always been committed to helping the Alzheimer Society provide vital programs and services that they deliver in communities all across Canada. That's why IG Wealth Management supports over 300 fundraising walks that take place in large and small communities from coast to coast. These walks serve as the largest annual fundraiser for the Alzheimer Society, with funds being raised in the community and staying in the community. And since our national partnership, the walks have raised over $5 million. So we think that's very incredible, and we thank everybody for their support. IG Wealth Management is also inspired to help the financial confidence of all Canadians, and we have taken that vision and extended into our new community platform, IG Empower Your Tomorrow. We're delivering financial confidence workshops, seminars, and resources in communities across the country to ensure all Canadians are able to take ownership of their finances with confidence and financial plans. Now, before we talk about why we have a plan, we should discuss what a plan is. A financial plan is a comprehensive review of someone's current financial situation and projections of how your financial situation may change in the future, all the way from retirement and beyond to end of life. A financial plan should cover every area of your finances, including your income, savings, debts, insurance, taxes, and planning for your eventual retirement and estate. The reason to have a plan is to establish what your financial goals are for both the short-term and long-term needs. Once you know what your goals are, you can review your current situation to determine what you are currently doing and how it will allow you to achieve your goals and whether any adjustments are needed. Your financial plan will evolve over time to adjust to changes in your personal and financial situations. Life is dynamic, and a financial plan should be dynamic as well. If you don't have a financial plan, then you're leaving your future financial situations to chance, and there's no ability to make the necessary changes to ensure you achieve your goals. But we're going to start off and talk about Canada's 3 pillars of retirement. When planning your retirement, there are 3 main sources of retirement income to consider that someone could potentially draw on. In financial planning circles, they're called the 3 pillars of Canadian retirement system. The first pillar of retirement income are government-administered benefits that consist of Canada Pension Plan, Old Age Security, and its supplemental benefits such as the Guaranteed Income Supplement, the Allowance for Spouse Common Law Partners, and Allowance for Survivors. With very few exceptions, every person who works in Canada is over 18 years old must contribute to either Canada Pension Plan or the QPP, Quebec Pension Plan in that province. And you may not be happy that your paycheck is reduced for the contributions you're forced to make while working, but once you choose to retire, you will have an income stream guaranteed by the Government of Canada. The old age security and supplemental benefits are universal in the sense that everyone is entitled to receive a benefit as long as they have been a resident of Canada for a certain length of time. I'm going to go into each of these benefits later on, but we'll move forward right now and just get to our next slide. The second pillar of a retirement income plan is employment-sponsored plans. You may be part of a company that have a registered pension plan, or you may be part of a company that has group RSP plans. Smaller employers, they often offer, the group RSPs or deferred profit sharing, or even employee profit sharing plans. The last part of the third pillar is personal savings. This is where you set up an account and contribute on your own. Financial planners recommend that you accumulate savings in addition to the previous 2 pillars for emergencies and achieving other financial goals. Probably the most common retirement account for Canadians is a registered retirement savings plan, especially for elderly clients, since the RRSP had been in existence for just over 60 years now. So pre-tax dollars are contributed into a registered retirement savings plan, and contributions grow tax deferred until money is withdrawn from the plan, presumably in retirement. The tax-free savings account is also a great tool and first became available for Canadians to contribute in 2009. The tax-free savings account does not provide a deduction for contributions today, but any withdrawals from the TFSA are not taxed either. So this plan works best where the retiree's marginal income rate is higher in retirement than at the time of contributions. So we're going to talk a little bit more about the individual government benefits I mentioned already. Most Canadians really look forward to receiving their old age security pension, or commonly called OAS. For the most part, if you are living in Canada and are a Canadian resident or legal resident of 65 years or older and living in Canada for at least 10 years after the age of 18, then you will qualify for at least a portion of the old age security pension. Most seniors will receive a letter from Service Canada the month after the year in which they turn 64, which notifies them that they will automatically be receiving their pension when they turn 65. In some cases, if you do not receive the automatic enrollment letter, you may still receive a letter from Service Canada stating that you may be eligible for the OAS pension, but have to apply for it. In that case, or if you do not receive any notification from Service Canada at all, you must apply to Service Canada to receive your old age security. The application form will be included with the eligibility letter or available on the Service Canada website. Now, in some cases, it may make sense to not take your old age security pension at age 65. You may defer your pension for any length of time up until age 70. Why would you do this? Well, as you can see, every month that you delay receiving your OAS pension, your monthly pension amount, when you do actually receive it, will be increased by 0.6% up to a maximum of 36%. This may be beneficial for seniors who have enough retirement income without OAS and who are expected to have long lives, or just those who are subject to old age security clawback. If you receive the automatic enrollment letter from CRA at age 64 but do not wish to receive OAS pension, you must send a letter to Service Canada with specific instructions to defer your OAS payments. The supplemental benefit, such as a guaranteed income supplement, is a non-taxable supplement to the old age security that is paid to seniors whose income is below a minimum annual threshold. This year, the annual threshold is just a little over $18,000. If a senior is receiving old age security and guaranteed income supplement, they will receive one monthly payment from Service Canada that includes both. For most seniors, you're automatically enrolled to receive the OAS, and that means you'll also automatically be enrolled to receive the GIS. In that case, senior will receive a letter from Service Canada that the month after they turn age 64, notifying that they will be enrolled in the GIS as well as the OAS. In the case that you do not receive an automatic enrollment letter, you must apply for the GIS at the same time that you apply for your OAS. People are also looking forward to receiving their Canada Pension Plan, which you're eligible to receive as a default at age 65. But there is the option to take the pension as early as age 60 or defer it until age 70. However, the pension is reduced if you take it earlier than age 65, and if you defer it past 65, you get a supplement. So unlike old age security, where some notification should be sent to you at age 65, there is no notification from Service Canada to remind you to take Canada Pension Plan. If you would like to receive your CPP pension at any time before age 70, you must apply for it. To apply for your CPP pension, it is best to register for an online account with Service Canada called My Service Canada Account. Once you have registered, you can log into this account on Service Canada's website using the personal access code and submit your application to start taking CPP. You can apply up to 12 months before the date in which you'd like your pension to start. Or if you are over age 65, you can request a retroactive payment back a maximum number of 11 months or back to your birth date of age 65. In certain situations, you may not be able to apply for CPP online, in which you may still be able to use a paper application form. This can also be attained at Service Canada's website or any Service Canada office. So how do you decide? Deciding when to take your Canada Pension Plan and old age security and ensuring you receive the correct amount of benefits is very important. First, you can authorize someone else, like a trusted family member or professional, to receive information from Service Canada on your behalf, either through this My Service Canada website or by completing a consent form on the service website or service office. This authorization would not give any person the ability to make instructions to Service Canada, but it does allow that person to communicate with the government and receive information specific to your situation. Second, an experienced accountant or financial planner will also be able to provide assistance in navigating the rules and help you plan for the best option that suits your situation. For seniors that are not capable of managing their own affairs or have other persons or government agencies already appointed to do so, certain individuals may apply to be appointed as a third-party administrator. This could be a third-party administrator who's a government employee or a department, or a power of attorney, which we will talk about later on. Other tax credits that might spring to mind when you're thinking about income that can come from the government is the disability tax credit. This is a federal non-refundable tax credit, and it is claimed on your annual income tax where there's a severe and prolonged impairment in physical or mental functions. Each province and territory may also have an equivalent tax credit as well. Being approved for a disability tax credit may allow for eligibility in additional credits and programs, such as the Registered Disability Savings Plan. How do you apply? It is a very simple process. You apply through a form called the T2201, and basically the individual will fill out page 1, and your doctor or medical practitioner will fill out the remaining 3 pages and have it submitted. It doesn't mean you're guaranteed, but it is a very simple process. Due to its value, this credit has been discussed in the news media for a number of times over the last couple of years. There are a number of organizations that have made it their business to help clients receive CRA approval for this disability tax credit by charging clients a percentage of their expected tax refund. However, when the tax credit is claimed for a number of years in the past, the tax refund and resulting fee to the disability tax credit can be substantial. I should point out that in order to claim this tax credit, the patient's medical practitioner must still certify on the Form 2201 the nature of the impairment, severity of the impairment, and how long the impairment is expected to last. If the medical practitioner has completed the form in enough detail to show that the patient is eligible for the tax credit, all that remains is to submit it to CRA for approval. Even in cases where it may be more difficult to show that the patient meets conditions for the disability tax credit and the tax account is involved, the fee for the accountant may be substantially less than using a third-party disability tax credit service. We also have new tax credits for attendant care. When someone is receiving private home care, living in a nursing home, or even in an assisted living or retirement home, some or all of the attendant care fees may be considered eligible to be claimed for the medical expense tax credit on their income tax. In order to claim an attendant care as a medical expense, you must have to obtain either CRA approval for the disability tax credit, or in some cases, certification in writing by your medical practitioner that the patient meets certain conditions. This doesn't necessarily mean you're actually claiming the disability tax credit, but you must have received approval to potentially claim the attendant care. The full amount of fees paid to a full-time care in a nursing home, excluding additional services such as cable or foot care, can generally be claimed as a medical expense if the disability tax credit has been approved but not claimed. So you have the option of either claiming the full amount of the fees as a medical expense or the disability tax credit, but not both. Now, there is one exception where you could put some of the attendant claim under a different tax rule. There is another rule that allows someone to claim fees paid for full-time attendant care that relates only to salaries and wages, up to $10,000 as an annual medical expense, and also claim the disability tax credit. This provision is usually used by those living in retirement homes, which will provide an annual statement that breaks down the total fees paid during the year that relate to various categories, including rent, food, eligible salaries, wages, as well as non-eligible salaries and expenses. The only portion of the total fees paid that represents salaries and wages for certain personal care services can be claimed as a medical expense. This rule can also be used by those living in nursing homes. However, the key is now that you need a breakdown from the nursing home on how much of the fees paid represent the eligible portions of salaries and wages versus other expense. Most nursing homes charge on a per diem basis and may not have the information or expertise to break down the total fees paid into the necessary categories. The number of tax rules that apply and the work in determining what documentation is necessary can make claiming attendant care a little confusing. CRA does have a pretty good discussion of attendant care in easy to read language on their website and in their medical expense guide. If these resources don't help, I would recommend that most people seek professional tax advice or financial planning advice on how the rules might apply to your individual situation. Now let's talk about the Canada Caregiver Credit and the changes we've seen over the past few years. For 2017 and later, the federal government consolidated a number of former federal non-refundable tax credits for caregivers under the new Canada Caregiver Amount Tax Credit. For 2016 and prior, there were a few different tax credits available to caregivers depending on the relationship between the caregiver and the dependent and the age of the dependent. Each credit had different criteria in order to be eligible for the caregiver to claim, but under the new Canada Caregiver Amount, a relative must simply be dependent on the caregiver for support due to physical or mental impairment at any time during the year, but the dependent is no longer required to live with the caregiver. So, although the government made it easier to determine whether or not you are eligible to claim tax credits for caregiver, the actual process of claiming the new Canada Caregiver Amount on your income tax return can still be a little confusing. Depending on who the dependent is to the caregiver, the Canadian Caregiver Amount is claimed on one of 3 different lines, and in addition, there may be increases to one of 3 existing tax credits already being claimed. The dependent's income decreases the amount of the credit is available to the caregiver. Now that we've talked about some of the income and taxes and credits that you're available to take out of our government support systems, we do want to talk about diminished decision-making capacity. Every adult Canadian should have a plan in place in case of a disability. It's very important to speak to an experienced advisor who will have the appropriate type of expertise, and do-it-yourself solutions are definitely not recommended. It's actually quite rare that someone goes from a situation where they are very comfortable making complicated financial decisions one day and then unable to make the simplest decision the next. In most cases, unless a person has experienced some sort of catastrophic event, the process takes place over an extended period of time. In many cases, people are aware of the fact that they are having more and more difficulty remembering things or making decisions, but they may feel defensive about their situation or unclear as what to do. The first thing people in this situation need to do is communicate with their doctor, financial advisors, family members, or trusted relatives about the challenges that they are experiencing so that they can get the type of help they need. One of the best ways of that is assigning a power of attorney. One very important legal document, a power of attorney for property, may have other names depending on the jurisdiction. This is a document where one person, whom we refer to as a donor, gives someone else, who we'll refer to as the attorney, the power to make financial decisions on their behalf. If you don't already have a power of attorney in place, you should make sure that you speak with an estate lawyer as soon as possible, because if you wait too long, you may no longer have the required capacity to sign a document. You need to do some planning well in advance of when you might actually experience a problem. And so what happens if you don't have a power of attorney? It can be quite difficult. A family member does not automatically have any right to act in the court. The court can choose someone who would not have chosen because they don't know what your preference might have been. So don't delay in speaking to an estate lawyer about putting a power of attorney in place. Spouses don't automatically have the power to act for one another, so even if you're married, be sure to sign the POA giving your spouse the right to act on your behalf. And it's also important to always have an alternate in case your primary attorney isn't able to do it. Confirm with your lawyer that it is an enduring power of attorney, meaning that it will be effective even once a donor loses capacity. Ironically, if you don't include some sort of clause indicating that the attorney is to be effective even once you no longer have mental capacity, the attorney will not be able to act once that happens. Designating somebody as your attorney does not detract in any way from your ability to manage your assets, so long as you still have the capacity to do so. Having a power of attorney in no way takes away from your ability to manage your assets, and in fact, you don't even need to tell your attorney that they have the power to act, but just let them know where you keep your important documents in case they need to access them at some point in the future. In many cases, clients will register their power of attorney documents with their financial institution, but will also speak to their financial advisor about when it might be appropriate to start taking instructions from an attorney. If a family member does try to access a document before it is appropriate to do so, you can rectify the situation by revoking the power. The problem with waiting too long is that you may not have sufficient capacity to sign a document by the time you really need it. So who should you pick as an attorney? It should be somebody very trustworthy. It should be somebody who is comfortable making financial decisions. So, for example, you wouldn't want to pick an adult child who cannot manage their own finances, or they may have difficulty managing yours. It should be somebody who is very organized and very diligent. And it should also be a resident of Canada. If you have an attorney who is a resident in the US, or even just a US citizen, it could result in extra complications in the form of additional tax filings and administrative headaches. So, as alluded to in the previous slide, the best way to avoid financial abuse is to make sure you choose someone who is trustworthy. However, the issue is a little more fundamental in that there are a lot of people who want to do the right thing. They have just never received any education on what an attorney can or cannot do. It may be recommended that you sit down with your potential power of attorney and explain that when the time comes, you would like them to manage your affairs on your behalf. But they should also speak to your financial advisor, potentially even your lawyer and accountant for assistance on how to properly manage your assets. Attorneys need to be accountable for every dollar of money that they receive and every dollar that is spent. The power of attorney can't transfer your assets into their name, and also generally can't do things like change beneficiary designations, add themselves or anyone else as a joint owner on an account, or borrow from the account. When attorneys understand the role in advance and are aware of the potential liability they will face if they abuse their position, they are much more likely to act appropriately. People need to consider the use of a corporate attorney in situations where they aren't confident that their attorneys will use their powers properly, which might be particularly the case if you have family members who are in precarious financial situations themselves. Joint ownership is also another rule that you have to watch out for, but I will say that adding children as joint ownerships to your property is generally a bad idea. It's one thing to add your spouse as a joint owner, but it's another thing to add a child. If a client wants someone to manage their assets if they aren't able to, the solution is to appoint a power of attorney. There is no reason to add a joint owner. There have been quite a few court cases where disputes arose because children started to experience their own creditor issues when they separated, divorced, or ran into other financial hardships. And the parents were very distressed to find out that a child's ex-spouse was claiming an entitlement to part of their assets. This was also a case out of BC recently where a mother added her son as a joint owner on her home. And although he didn't even realize that he had been added as a joint owner, that didn't stop his creditors from putting a lien on the mother's home when his business started to go into default. Also, adding a joint owner doesn't help in most cases when managing assets. For example, if you had a child as a joint owner of your home, you would still need to appoint your child as your power of attorney to consent to the sale of the home if you were to be moved into an assisted living facility. So as long as your name is even partially on title, you still need a power of attorney. Problems can also arrive at death. Is jointly held property to be kept by the child in addition to his or her portion of the estate? The other financial issue is abuse. It is much easier for a child to misappropriate funds when they are a joint owner of an asset, since it's much like having a financial basket, and a financial institution will likely not question them when making requests for large redemptions. Another problem is you can't simply change your mind if you add a child as a joint owner. This has been a case where parents have had to go through court and try to get their children removed from their assets, and the courts haven't authorized the request. With a power of attorney, if you feel that your attorney is being abusive of powers, you would just simply revoke the power. So the risk of incurring thousands of dollars in litigation legal costs generally isn't worth the time of trying to save a few $1,000s of probate or setting up a power of attorney. Some clients also ask about transferring assets to family members. Completely transferring an asset to a family member is even more dangerous than joint ownership, since you are now completely giving up control of your assets. Nursing care costs in most jurisdictions are based on income, not assets, so transferring your assets to another person usually doesn't help. Even in those few jurisdictions where nursing costs are based on your assets, the government will look back over any transactions carried out over the past few years, and if they find out that you recently transferred all of your assets to your child or a trusted family member, you would not qualify for the reduced rate anyways. And since you never know when you will actually need to go into a nursing home, it's pretty much impossible to time it properly. If you want to minimize your nursing care costs, you should speak to your financial advisor first to see what rules are in your province and how you can work within them. You should also look into whether long-term care insurance is an option for you. Giving up control of your assets is a very dangerous strategy, which could put you in a very precarious financial situation. The way to alleviate many of these concerns is to make sure you have a good financial plan in place. In many cases, when clients express these concerns, it's usually as a result of a lack of education about nursing care costs, living costs, what their income will look like in retirement, and also when they may be receiving Canada Pension Plan and Old Age Security. If you are concerned about paying for nursing care costs, ask your financial advisor about how to reduce them. In many cases, we can do projections for clients which illustrate that they will have nothing to worry about because they will have sufficient retirement income to pay for the care, or they are able to fairly easily adjust their annual income in order to reduce the overall cost of care. Don't take any drastic measures like giving away your assets before understanding the implications. It may not reduce your nursing care costs in any way and may in fact cause a lot of extra tax when you transfer the assets to a child because you could trigger taxable gains or income. And the bottom line is that you will now be in a very precarious position. If you want peace of mind, you need a financial plan. We don't like to talk about it, but unfortunately, financial abuse is something we see with some elderly clients. If you do have suspected financial abuse, it's generally perpetrated by close family members or friends. But there's also a lot of financial abuse perpetrated by third parties. These type of criminals are usually very sophisticated. Clients sometimes feel embarrassed talking to their family or friends about possible financial abuse because they feel stupid for letting it happen. Keeping in mind, many intelligent people have been the victims of financial abuse, so there is nothing to be embarrassed about. One of the main tactics abusers use is to isolate their victims and convince them that they can't tell anyone what is going on. There have been many cases where financial institutions questioned transactions that the client was requesting, and the client lied to their financial advisor or institution at the instruction of the abuser. If anyone tells you to lie to your advisors or your family about how you are spending your money, that is a massive red flag, and that is possibly a scam. The reason they don't want you to talk to your advisor about it is because financial advisors usually have training in terms of how to spot financial abuse and protect our clients. There are also a lot of romantic scams out there, so be very wary of any number of Facebook friends who you've never met in person. No one you've ever met should be asking you for money or personal financial details. There are also a number of inheritance scams where con artists ask you for money or financial information under the guise of needing it to confirm you are a long-lost beneficiary under a will they found. If you actually are a beneficiary, you shouldn't need to be providing money or financial information. So if anyone asks you for this information, you should speak to an advisor first to make sure that it is legitimate. If you think something is suspicious, the first thing you should do is speak with your family, an advisor, or the police. The worst thing that will happen is that they will tell you there's nothing to worry about. So where to find information? It can be difficult to find good advice. The first thing I'd mention is that the facts can be verified by going directly to the proverbial horse's mouth instead of relying on secondhand information. For example, we talked a lot in the beginning about Canada Pension Plan and Old Age Security. These are pensions, as I mentioned, are administered by Service Canada. So Service Canada's website has lots of information specifically on these two pensions. If somebody has questions about income tax, the Canada Revenue Agency administers our income tax system. So the CRA website has extensive information in layman's terms on what you need to know about your income tax return. However, having facts on policies and rules doesn't always help you interpret how they may apply to your own individual situation. Sometimes it can be difficult to understand the information that you have accumulated, so in many cases, it is best to see a professional for advice to determine how to proceed. When trying to find a good professional, make sure that the professional is educated in the area in which you need expertise. For example, don't go to an accountant to get legal advice, or you don't go to an insurance agent to get tax advice. The next step is to ensure that the professional has sufficient education designations to be able to provide you good advice. Ask the advisor or professional what the designations are and what their credentials are. Choose advisors with the right credentials. For example, when choosing a financial planner, ensure you choose somebody who has a certified financial planner designation. When choosing a lawyer, it's best to have a lawyer that has a TEP, or the Trust and Estate Practitioner designation. You want to make sure that you're getting advice from people who really do specialize in the areas. Some lawyers will dabble in things like wills and power of attorneys, but don't specialize in that area, and sometimes the advice isn't really helpful. There are lots of people who do specialize in helping people cope with aging, so you don't just pick the first person you happen to meet. Ask them about their area of expertise so that you can make an informed decision when choosing your advisor. I would like to thank you very much for your time, and I believe at this point I will go back off mute and Christine can take over and we'll see if there are any questions.
Great, thanks so much, Cam. I think that the information is absolutely relevant no matter your age, no matter your income, whether you're living with dementia, have been diagnosed, or suspect. All of it is really valuable information to have, especially in supporting our clients, because these are often questions that we receive from them. And I think that our first question, everyone, please feel free to type in any other questions you might have for either of the presenters. But the first one is a good one for sure. Can Investors Group help with all the things you were speaking about? And is step one connecting with Investors Group? And then Cam, maybe before you answer, could you give people a little bit of an idea of where you're located and how they could get in contact with you if they'd like?
As mentioned at the beginning, Alexis and I, we do work as a team, and I am a certified financial planner and a registered retirement consultant as well. So I do deal with a number of clients that are elderly, older than myself as well. And so I am able to help with many of those aspects that we talked about earlier, whether it's explaining the tax systems, giving advice on what a power of attorney should look like, even though you will go to a lawyer for it, and just making those good decisions of saying, where are you today and what does the future look like? Whether you maintain your health or not, that's the advantage of a financial plan. As far as getting in touch, that is always the first thing we do. If we're going to be providing advice, this year's been virtual, but generally in the past, you always sit down and just find out what's important and how does your personal situation look. There is no cookie cutter approach. Myself, I am located in St. Albert, but I have clients all throughout Alberta and even into BC. With the virtual meetings right now, it makes travel so much easier, or lack of travel. But we are willing to move around, into different areas.
It looks like you have one more question. Can you help with international assets?
And where those international assets are located, I do have clients where we've dealt with assets out of Great Britain or the United States, but it would depend where it is and if we'd have any expertise in different jurisdictions. Okay, and actually, I just saw there was another one that came up. I am definitely able to connect with other people in other provinces, for those that need it in, different IG reps in different regions. I am licensed in Alberta and BC, but I have a number of great colleagues that I trust, in different areas from coast to coast.
Okay, that's really great information to know. And one last comment, awesome, thank you very much. And I would agree. Oh, sorry, we do have one person who just made a comment. She had just wrote that was her question too, in regards to connecting people in other provinces. She says, I'm the power of attorney for my parents in Manitoba.
Okay, no, that'd be terrific. Anybody that's online, they can connect with us. Yeah, I believe our contact information is on the other pieces that are going to be sent out. It's alexis.dallaire@ig.ca, or mine is cam.lowe@ig.ca. And our direct number is 587-764-0202. And I can definitely help anybody like this POA for parents in Manitoba. We'd be happy to help you and put you in touch with somebody that can give you the proper advice.
Absolutely right. Everyone will receive, and those who did not registered but did not attend today for whatever reason will receive all of the information that you have attached.
Okay, terrific.
Perfect. All right. Well, with that, I will say thanks again for your time, Cam, this afternoon. And thank you, everyone, and have a great afternoon.
Yeah, thank you for everybody that attended, and thank you for your time. Have a great weekend.